Hello everyone, my name is Priya and I welcome you all back to my channel PictoLearning. I hope you all are doing great. In the last video, we discussed Article 49 of the Indian Constitution. If you haven't seen that video yet, then the link is given in the description box. Moving ahead in our series, today we will be discussing about Article 50. Article 50 talks about separation of judiciary from executive. Judiciary means a system of courts of law. It protects the rights of every citizen, administers justice and settles disputes. Executive means that part of government which enforces or executes or carry out the law. Article 50 comes under liberal intellectual principles. The provision of Article 50 says that the state shall take steps to separate the judiciary from the executive in the public services of the state. In simple words, this article wants to say that it will be the responsibility of the state and the authorities of the state to keep the executive and the judiciary completely separate from each other. Neither the executive will interfere in the work of judiciary, nor the judiciary will interfere in the work of executive in the public services of the state. Public service means something that government provide to citizens. That is, it will be the responsibility of the state to ensure that both these systems do their work separately in the interest of the public. Okay? Now here, to understand this article in a better way, we need to understand the separation of powers. We all know that India is a democratic country and democracy has three pillars: legislative, executive and judiciary. Legislatives are those who make laws, executives are those who implement laws, and judiciary whose work is to interpret laws, that is to intervene between the center and the state, between the state and its citizens, or between the states. Legislature will be handled by Parliament including Lok Sabha and Raj Sabha at central level and state legislative bodies at state level. Executive will be handled by President at central level and by Governor at state level. And judiciary will be handled by Supreme Court, High Court and other subordinate courts. This division of powers is also known as Res Politica or the Doctrine of Separation of Powers. And this theory, that is separation of powers, is proposed by the French philosopher Montesquieu, and USA is the first country which adopted the concept of separation of powers. Now, to understand the concept of separation of powers, here we have to understand two systems. One is democracy and the other is monarchy. Democracy means elected rule and monarchy means hereditary rule. In India, we follow elected rule, where the representatives are elected by the people. That is why India is called democratic country. If you want to take an example of monarchy system, then that is Britain, where the king or the queen is the head of the state. Monarchy system is a years-old system where kings and emperors used to rule. This system remained in India for centuries. This article, that is Article 50, explains the difference between British power and Indian power in India. See, since 1858, when the British Crown was ruling India, all the powers were concentrated at one place. The person who used to make the law, the same person used to implement that law and also used to decide punishment on breaking the law. There used to be no transparency in the administration. So to avoid the concentration of powers at one place or with any one person, to avoid the misuse of these powers and to do justice with the citizens, hence the concept of separation of powers was introduced. And we all know how much these powers were misused during the British rule. So when India became independent, then India became a democratic country and these powers were separated so that there is complete transparency in the administration. No one can misuse these powers and no injustice can be done to any citizen. And Article 50 is a form of that separation. So overall, if we see, there are a lot of advantages of separation of power. Like the doctrine of separation of powers is to prevent the misuse of powers within different parts of government. It will preserve democracy of the country. It will safeguard individual liberty. If different parts of the government are handled by different specialized people, then the decisions will be better. And with this separation of powers, the concept of checks and balances will also be there. Checks and balances mean the three pillars, that is legislative, executive and judiciary, will be able to keep an eye on each other. So that if one part takes some wrong decision, the other can stop it. Because if any one part starts processing wrongly, then it will not be right for the country and its people. For example, if the legislative and executive body makes a law, that means if the parliament makes a law and the president passes that law, then this law goes to judiciary for judicial review. During the judicial review, the judiciary checks whether this law is constitutional or not. That is, the judiciary checks if this law is not violating any fundamental right or the basic structure of Indian Constitution. And if during the judicial review the law is found unconstitutional, then judiciary declares that law null and void. So judicial review acts as a kind of checks and balances, and that is why it is also said that the concept of separation of powers is not as rigid in India as it is in the US. This concept is followed quite rigidly in the US. So the primary goal of the separation of powers is to maintain checks and balances between the three pillars of the government. Okay? So we have understood that what is the separation of powers, how and in which branches it is divided, and why the separation of powers was done. That is, we have seen the advantages of separating the powers in the government. So the basic philosophy behind the theory of separation of powers is that there shall be no concentration of powers in a single hand. Now, after understanding all these details, it is very easy to understand Article 50. So as we saw in the beginning of this video, Article 50 says that it will be the responsibility of the state and the authorities of the state to keep the executive and the judiciary completely separate from each other. Neither the executive will interfere in the work of judiciary, nor the judiciary will interfere in the work of executive. This will restrict the authorities' unfair use of their powers. And as we have discussed, the main aim of the separation of powers is to maintain the check and balance system among all the organs of the government. Now, one thing to be understood here is that if you ask where this term separation of power is written, because no such term has been used directly in Article 50. So the answer is nowhere. This term, that is separation of powers, has not been directly mentioned anywhere in our constitution, but there are many such articles from where we can understand that the concept of separation of powers is followed in India as well. So which are those articles? So those articles are Article 50 talks about separation of judiciary from executive. Article 121 talks about restriction on discussion in Parliament with respect to the conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties. Article 122 says that courts cannot inquire into proceedings of Parliament. Article 123 says that the President can use his executive powers under certain conditions. Article 211, same as Article 121, talks about restriction on discussion in the legislature of a state with respect to the conduct of any judge of the Supreme Court or of High Court in the discharge of his duties. Article 211, same as Article 122, says that courts cannot inquire into proceedings of the legislature of a state. And Article 361 says that the President or Governor not answerable to courts. Article 121 and Article 122 are for central government, and Article 211 and 212 are for state governments. Okay? Now, according to an important case of 1973, that is Keshav Nanda Bharti case, separation of powers comes under basic structure of Indian Constitution. In this case, the Supreme Court had said that the Parliament has the right to change the provision of the Constitution, but it shall not change the basic structure of the Indian Constitution. Thus, doctrine of separation of powers has been considered as integral part of the basic structure of the Constitution. So these were the details related to Article 50 of the Indian Constitution. I hope you must have found this video informative. So that's all for today from my side. I'll see you in the next video. Till then, thank you so much for watching PictoLearning.